A friend of mine built a B2B marketplace over 6 years, exited for $150 million, and walked away with almost nothing. And this was because he made several legal mistakes during fundraising that came back to destroy him when his exit came around. Unfortunately, this happens more often than you'd think. Being a startup lawyer, having founded 2 software companies myself, and having done hundreds of venture capital raises, I have seen it all happen too many times. So in this video, I'm breaking down the 6 legal mistakes that actually kill startup deals and how to avoid them so that you don't end up as another one of those founders. Let's dive in. Mistake number 1, asking investors for an NDA. One of the most common mistakes founders make is asking investors to sign an NDA straight away. This is the fastest way to get ignored because it signals you don't understand how the fundraising game works. Investors talk to hundreds of companies, many in similar spaces. They can't bind themselves with NDAs from every founder they meet. It's just not how the VC world operates. So here's what you should do instead. Use a phased approach to releasing information. Your pitch deck should have the most exciting, high-level stuff, the public-facing content, but the deep dive into your tech and data should happen after receiving a term sheet. You should use a virtual data room like DocSend so you can track what investors are looking at and make sure to do your due diligence on the investor. Ask about their portfolio companies, check for competitors, talk to other founders that have dealt with them, then push the investor to give you a term sheet before you share the sensitive data. Mistake number 2, optimizing for valuation over terms. The next mistake founders make is optimizing for the largest valuation possible rather than optimizing for the best terms possible. This is an emotional trap. Founders get obsessed with announcing their valuation. They want to say, I raised at $1 billion valuation, or we're a $50 million company. So they push the valuation up and accept terrible terms to get there. But the terms are actually what matter. The terms in your investment documents get filed away and then come back to haunt you at exit. That's when you actually feel the heat from the deals that you signed years ago. The story I talked about in the beginning, that's actually a true story. And it was because of this exact mistake. I know a German entrepreneur who built a B2B marketplace. He exited for $150 million, which sounds amazing, right? But he walked away with almost nothing. Just the numbers after the comma, because he optimized for valuation, accepted bad terms, then the economy changed. He couldn't raise the next round on good terms. And the liquidation preferences and participating preferred clauses destroyed him. So after spending 6 years of his life building that company, he left with basically nothing. So the lesson here is you need to model and understand what these terms actually mean for your exit. Work with advisors who can help you see the long-term impact of what you're signing. Speaking of which, if you're raising right now and you want help understanding what terms actually make sense for your specific situation, click the first link in the description to book a free consultation with me. We'll look at where you are and make sure you're not signing something that's going to hurt you down the road. Now back to the video. Mistake number 3. Falling for the drag and drop. Another common mistake founders make is falling for the drag and drop. This is what it means. An investor gives you a term sheet. You get excited because you think the deal is basically done. So you stop conversations with other investors because you don't want to waste your time. Then the investor starts dragging things out week after week, which means 6 weeks later, you're trapped. Your round has gone cold. Other investors have moved on. You have no leverage anymore. Now the investor comes back and says, we're going to do the deal, but and they add 1 or 2 unfavorable clauses, and a lot of founders still accept the deal. They've invested so much time with this one investor. They have no other options on the table. They're scared and they need the money, so they take the bad terms. In reality, this is completely avoidable. Never stop other conversations until the money is in the bank. Run a competitive process by having multiple investors interested. Don't count your money until it's actually wired. Until that happens, anything is possible because term sheets are usually non-binding. Mistake number 4, not having proper contracts with co-founders and early team. The next mistake is not having proper contracts right from the very start. A lot of founders in the early days operate on handshake deals and verbal promises. You tell an early employee or advisor, we'll figure out equity later, or you bring on a co-founder and never actually document who owns what. This creates massive gray area that can blow up in your face. Someone could come back and claim that you promised them 10% of the company at a bar one night. Even if it's an unserious lawsuit, you still have to respond to it. And I see this all the time. It does actually happen. We had a founder who worked with someone early on. Their work was pretty bad, and they never signed a contract, and they just parted ways. But because there was no documentation, that person could still come back and allege that they were promised equity. And unfortunately, the way the courts are set up, all lawsuits are given credence and treated as valid until proven otherwise. But as well as this, not having the right contracts also kills deals during due diligence. When investors look at your cap table, they want to see clean documentation. If there are undocumented equity promises floating around, it creates massive uncertainty. The investor's lawyer sees a messy data room, and this tells them that something is off. So get your contracts in place from day one. Document every equity grant properly. Make sure your cap table ties out exactly. No unaccounted shares or options. If someone does work for your company, get it in writing. What they're getting and what they're not getting. And as a side note, this also applies to IP agreements. Make sure you have all your contracts in place. Mistake number 5, ignoring dirty term sheet clauses. A mistake you should definitely avoid is ignoring dirty clauses on investors' term sheets. The most common dirty clause I see is the option pool shuffle. This is where the investor requires you to create an employee stock option pool before they invest. This dilutes you and makes their investment more valuable. So they get a larger percentage of your company than you realized or intended. You need to push back on this. Go into negotiation with a hiring plan. Build out your org chart for the next 18 months. Assign equity to all those future hires. Show the investor, actually, we only need a 10% option pool based on this plan, not the 20% you're asking for. Another common clause is the double dip. This is where the investor gets to make their investment back through liquidation preference. Then they convert to common stock and participate in the remaining proceeds too. So essentially, they get paid twice. The bottom line is you need to understand what you're signing. These clauses look innocent on paper, but they destroy you at exit. Work with a lawyer who actually understands venture deals. This next mistake is one that founders don't even know is a problem, but it can completely disqualify you from ever raising again. Mistake number 6, paying finder's fees for investor introductions. This is actually illegal. A lot of founders don't know this. People with connections to investors always ask me, how can I get paid for making introductions? They want success fees, a percentage of what you raise. But this is a huge problem. Unless someone is a registered finder or broker, you cannot pay them for introductions. Success fees for investor introductions violate the regulations, and the consequences are serious. You can be barred from ever raising investment again, and the investor can be prevented from making investments in the future. Both of you get in trouble with the SEC. Here's the proper way to structure it. If you want to compensate someone, it has to be a consulting fee, not tied to whether the introductions are successful or made. You're paying them for a job, like investor relations work. It cannot be you get X% of whatever I raise from your intros. Or they can get hired at your company and provide actual services in a certain role. Look, I know all this legal stuff can feel overwhelming, so if you're a startup founder and you want to make sure you're not making any of these mistakes, click the first link in the description to book a free consultation with me. We'll look at where you are, identify any legal gaps that could hurt you down the road, and map out exactly what you need to do to set yourself up for success. Again, click that first link below to book your free consultation. And if you want a full beginner's guide to understanding startup equity, then watch this video next.